Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about a major development in the legal challenge to Justin Trudeau's use of the Emergencies Act. Trudeau used this extraordinary law in February of 2022 to criminalize protests and freeze bank accounts in response to the Freedom Convoy, a group of protesters in big rig trucks who protested in downtown Ottawa and blockaded some border crossings. They were protesting a new government vaccine mandate for truckers, as well as other pandemic related restrictions. The Emergencies Act is an extraordinary law that allows the Prime Minister and Cabinet to create new criminal law basically with the snap of their fingers. It's only available when the high thresholds in that law are met: insurrection, terrorism, war, or massive natural disasters. Trudeau used the Emergencies Act for what's called a public order emergency. But did one actually exist? A legal charity that I work for, the Canadian Constitution Foundation, said no. And in January of 2024, the federal court agreed, finding that Trudeau had illegally invoked the act and used it to create unconstitutional regulations. That case has now been appealed to the Federal Court of Appeal, where it was heard last week. Here today to discuss the case are Joanna Baron of the Canadian Constitution Foundation and Sujit Choudhry, who represented us in that case. Thank you both so much for joining me today. Sujit, let's start with you. Can you explain what the Emergencies Act did when it was invoked? What were those regulations that were created?
Sure. So the act was invoked in February 2022 in the wake of protests across Canada in opposition to pandemic era restrictions at the border and other mandates. And when the act was invoked, the cabinet then used kind of extraordinary powers it granted to restrict peaceful assembly and expression across Canada, not just where the protests were taking place, and also to freeze the bank accounts of hundreds of Canadians who had broken no other law.
Now, Joanna, maybe you can give a little bit of color to how those regulations actually played out in practice. What did their application look like when they came into force?
So they were extremely broad in scope and were applied extremely broadly. So, for example, the emergency measures captured people who did not create blockades and who were just showing up on Parliament Hill peacefully protesting. It allowed police officers to arrest anyone and prohibit any assemblies that could reasonably lead to a breach of the peace, which is obviously a very wide standard. And then the economic measures, which were the most notorious part of probably this whole affair, directed bank accounts to freeze, directed banks to freeze bank accounts of specified individuals. And it's important to emphasize that these were not just limited to blockade participants, and the government's disclosure of this information required extensive personal information. It required extensive information about people's
Mhm.
license plate numbers, social insurance numbers, really sweeping.
Now, Suji, this was the first time this piece of legislation had ever been used, and the history of the Emergencies Act is actually crucial to understand. And for this case, what can you tell me about that history?
Sure. So just on the first point, it's important to remember that Canada has faced terrorist threats. We had 9/11. We've had sort of serious threats to national security since the act was enacted in 1988, but it was never invoked. It was only invoked in response to these protests, which were for where there was no serious violence and no serious destruction of property. And so the act was enacted in 1988, and it was a direct repudiation of the War Measures Act, which was the federal emergency legislation that had been invoked in the First World War to intern German Canadians, in the Second World War to intern Italian and Japanese Canadians, and then most recently in 1970 in the October crisis in Quebec. And sort of in a nutshell, the October crisis was precipitated by a terrorist threat by the FLQ, which had engaged in a campaign of bombings, kidnappings, and murder to fight for an independent Quebec. And the act was invoked, and there were mass arrests of hundreds of people.
Mhm.
At the end, there were very few convictions, and the FLQ was alleged to be a state within a state, but there were really just a handful of LQ members.
Right.
And so basically the bottom line was that we panicked overreacted in
Hmm.
1970. And the point of the act was not to do that again.
We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're talking about the recent hearing at the Federal Court of Appeal in the legal challenge to Justin Trudeau's invocation of the Emergencies Act. Now, Joanna, one of the standards to invoke the Emergencies Act is that there needs to be a threat to the security of Canada, and this needs to involve serious violence. And the term serious violence is a term that's known to law. It doesn't just have any meaning. It just doesn't mean whatever the government says. So the thing that was interesting about this hearing is that the government seems to be claiming that it, serious violence includes harm to Canada's economy. Maybe you can help me understand what that argument is about and maybe some of the problems with it.
Yeah, so this argument was particularly wielded by then Deputy Prime Minister Chrystia Freeland, who argued that economic security is part of national security, and threats to Canada's supply chains, for example, constitute threats to national security. She really harped on this at the Public Order Emergency Commission. But it has been noted throughout the hearings, and in fact accepted by Justice Mosley in the lower court decision, that serious violence indeed means violence to persons or damage, like physical damage to property, not mere shutdowns of the Rideau Center. And that's consistent through the Emergencies Act, the debates, and the CSIS Act. But what was interesting, as you mentioned, is that the government's lawyers on appeal very clearly tried to revive this already rejected argument and suggested that parking a truck on Parliament Hill could constitute a threat of serious violence on the order of terrorism. So they haven't let this go yet.
Really, some really strange arguments where the Crown's or the lawyer for the Attorney General seemed to suggest that running a big rig truck into a border building was the same level of threat as parking a truck in front of that same building. And I would just suggest that destroying a building is more serious than parking in front of a building. It's a sort of bizarre argument. Now, one of the other thresholds to invoke the act, Sujit, is that there needs to be a national emergency. And the lower court held that there wasn't one. So we know that of the different premiers of the provinces, 7 out of the 10 did not want the Emergencies Act invoked to apply to their province. So what does that tell us about whether or not there was actually a situation that applied nationwide?
Well, there probably wasn't. And I think, one of the most powerful um, points that was made by the government of Alberta in the case was that, Premier Kenny had gone on the record saying that we didn't want the act invoked. The RCMP had been able to resolve coups where there was, to be candid, an arms cache discovered and explosives, and it was a serious situation that was prevented by the RCMP using the criminal code. And he said we don't want the act invoked. And I think what was powerful in the hearing was that the government of Alberta said that we had a right to have Premier Kenny's views reckoned with and grappled with
Hmm.
by the Prime Minister, and they weren't. And the fact that 7 out of the 10 premiers said they didn't want the act should have led the government to then maybe, if they had to, invoke the act in those provinces which didn't object. And our view was that the only place plausibly to invoke it would have been Ontario, and even there it wasn't necessary.
Joanna, the Emergencies Act has been characterized as a tool of last resort because one of the thresholds for using it is that there is a national emergency that can't be dealt with under any other law of Canada. And we've argued at the CCF that there were various criminal law powers, that law enforcement tools could have dealt with this situation. And in fact, we heard from CSIS that there was no threat to the security of Canada, from the premiers that existing tools were sufficient, as well as from law enforcement, including the RCMP. So what does that tell us about whether or not existing tools had actually been exhausted?
Well, I think the proof is in the pudding. So when you talked about, Sujit mentioned the incident at Coots, which was indeed concerning. That was cleared using ordinary policing techniques. There was, of course, the blockade of the Ambassador Bridge, which is a huge trade artery, also was cleared using, a show of police force and ordinary policing techniques. And so the government has the obligation under Section 58 of the Emergencies Act to explain why it is the last resort. And in this case, its explanation just stated that this cannot be dealt with under the laws of Canada, but that really glossed over the underlying reality. And in fact, how they cleared the protest in Ottawa, which was not using
Mhm.
extraordinary powers.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the legal challenge to Justin Trudeau's invocation of the Emergencies Act in response to the 2022 Freedom Convoy, a legal challenge brought by the charity that I work for, the Canadian Constitution Foundation. Now, Sujit, one of the major issues in this case relates to the freezing of bank accounts. So once the Emergencies Act was invoked, uh, there was a regulation that ordered financial institutions freeze the bank accounts of, quote, designated persons. So people who were affiliated somehow with the protests. And a big question has been whether or not this violated Section 8 of the Charter, which guarantees the right to be free from an unreasonable search and seizure. So how do you think the courts are going to think about that question? And what have we argued about it?
So the core issue in the cases on Section 8 is whether the seizure of property is in connection with a criminal proceeding or an administrative one. And we argued quite strenuously, and I think the court agreed, that the seizure was related to criminal prosecution of protesters, because the point is that the persons whose accounts were frozen were either protesters themselves or persons who'd funded protesters. And I think the court was quite moved by the stories of the impact of the seizure on individuals. So one of the four appeals that was heard together was by two individuals whose accounts were frozen. One had to drive back from Ottawa to New Brunswick, which is a very long drive, over 10 hours, without access to his ATM card, and he had very little cash. So somehow
And
he
in the
managed to
dead
make
of winter in Canada.
it. Yeah, and so it was pretty heartbreaking, and we also have other stories of people who missed rent payments, people who missed child support payments, and most Canadians live paycheck to paycheck, and affordability is a huge issue right now in Canada, and so for those folks, having their bank account frozen for even a few days can be devastating.
And what's interesting about that is the information from those accounts was given to the RCMP. This the
Yes.
government has said that this was not related to criminal prosecution, but it kind of, why would the account information be sent to police if it were not to be part of a criminal prosecution? And this is really deeply personal information. I mean, I don't like really my husband looking at my credit card bill, let alone Justin Trudeau and the police. So I mean, it's really serious issue. Now, Joanna, another interesting development in this case was that the government switched lawyers in this appeal. Now, obviously, they lost at the lower court, and I think they spent a tremendous amount of money only to then lose. But they've now hired a private sector lawyer. Maybe you can tell us a little bit about that and tell us what you think is going on there.
Yes, they hired a lawyer from McCarthy Tétrault in Vancouver. He's an excellent lawyer. And we know you mentioned that they spent a lot of money up to the case at first instance. So we know that that was almost $2.3 million. So I know based on the budget of McCarthy Tétrault lawyers that that budget likely at least doubled. And look, I think it just reflects the fact that maybe they noticed they were outclassed. And either way, they understood that there was a steep hill for them to climb here because Justice Mosley's decision was very legally sound, was well reasoned, was something that he took, a period of more than 6 months to deliberate upon. upon, but I also think it, speaks to the government understanding that this is a precedent that's going to be difficult to make future governments invoke emergency powers, and
Hmm.
Canadians should ask themselves why they're willing to spend so much money and throw everything at the wall to defend their right to freeze bank accounts, and have police shut down peaceful protests.
Now, Sujit, very briefly, the other charter issues in this case, the major ones, involve 2B, freedom of expression, and 2C, freedom of assembly. And the lower court found that the limit on protests violated 2B, but not 2C. Really briefly, what can you tell us about what's being argued now?
Right, so we cross appealed on Section 2C because we felt that for the very same reasons that Justice Mosley rightly found that the emergency measures violated 2B and couldn't be justified under Section 1, the same reasoning should have applied to 2C. And because essentially what was prohibited was expression engaged in collectively by people gathering together physically, and that's the definition of an assembly.
Yeah.
And so we'll see how that goes.
Yeah, I mean, there's not a whole lot of case law on TC, but certainly the people who were protesting were assembling. Some of them were assembling totally peacefully, and if there's a prohibition on that, it engages the charter. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the appeal of the legal challenge to Justin Trudeau's use of the Emergencies Act. Now, Sujit, I don't want to get too technical here, but one of the interesting issues in this case has been an argument that you might call it a provocative argument that the federal government has made that they are entitled to a special heightened level of deference to their decision to invoke the Emergencies Act. They've essentially suggested maybe a double or even triple deferential standard for this decision to invoke. Can you explain, what deference is and what is so sort of strange about what the government's arguing here?
Well, there are two things the government was arguing there. The first is that they said that since cabinet is the apex decision maker, at the top of the Canadian executive, it should get special deference, and that's kind of arguing for an imperial cabinet in a way that is reminiscent of how some people argue in the United States for an imperial presidency. And so that should tell you enough of what we think about it. It's a dangerous argument, and it's an argument for a blank check. Um, they also held that that was what required was double reasonableness. That is, uh, reasonable grounds and then a reasonableness determination of whether the emergency was should have been invoked or not. And that doesn't make any sense. And the court really was quite confused by it. So I'm not sure that argument's going to go anywhere.
Yeah, I hope it doesn't because I think that we need accountability from government, and this is just granting such unrestrained authority to the executive. It's really concerning. Now, Joanna, one thing that people might remember about this case is that there was a public inquiry into the decision of the federal government or the federal executive to invoke the Emergencies Act with a commissioner. It was called the Public Order Emergency Commission, and there was a commissioner named Commissioner Rouleau. And Rouleau actually reached a conclusion that was different from the federal court. He said that the decision of Trudeau to invoke was reasonable, but different people could reach different conclusions. A sort of not too definitive result, but this has been cited by a lot of people who've defended Trudeau's use of the Emergencies Act. So, what weight does that commission decision have, and what role might the evidence from that inquiry play in our case?
So it's not legally binding, obviously, because you had two different conclusions that Rouleau came to. Even though it was not a legal finding, it was a recommendation and a sort of summary of the evidence as he assessed it, even though he is a judge. However, there's no question that something like, an extensive commission, which had, the entire cabinet, including the prime minister, testify, does carry some persuasive authority. Now, the other thing to mention is that prior to the Rouleau Commission, our litigation team had been fighting tooth and nail over every piece of evidence and disclosure. And then over the course of the commission, there was just an avalanche of literally thousands of pieces of evidence. So that had a huge effect on the evidentiary record of the case. And interestingly, the government's lawyers on appeal quibbled with some of the evidence that was disclosed during the Rouleau Commission, but seemed to want to rely on Justice Rouleau's ultimate non-legally binding finding.
So they wanted to have their cake and eat it too, I guess. So, Sujit, I've called this a once in a generation civil liberties case. Is probably going to be studied by law students for many years. What can you tell us, really briefly, about how important this case is and how important it is we get good guidance from the courts about this extraordinary law?
So the thing is that emergencies are fast moving and it's difficult for courts to adjudicate them in real time. And so what we need from this court in this case is guidance about the act and how it should be interpreted. So we have some ground rules for the next time we have to invoke the act if we ever have to.
Yeah, so important. Joanna, anything to add there on the importance of this case long term?
Yeah, I mean, it will send a huge signal to future governments about how they should approach this. And if the government's interpretation wins, they can basically dismiss all of the very specific statutory guidelines that we know were fought and placed there very deliberately when this act was adopted.
Joanna, Sujit, thank you so much for coming on today to tell us about this important appeal, and good luck to all of us.
Thank you.
We've heard today about the legal challenge to Trudeau's use of the Emergencies Act. What do you think the Federal Court of Appeal will decide? Will they agree that the first ever use of this extraordinary law was illegal and unconstitutional? How will Trudeau's use of this law be remembered? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.